All rise!
The Court of Appeal is now in session. For the case of Civil Appeal Number WA11B NCVC 15812 of 2020 between Razman bin Talib, the appellant, and the Inspector General Police, the respondent. The Appellant Solicitor, you may now submit your case.
My Lord, this is an appeal by the appellant against the judgment pronounced by the High Court of Kuala Lumpur on 20th of October 2020 in the favour of the respondent in the civil case number WA11 BNCVC 15812 of 2020, wherein the learned High Court Judge Lim Chong Fong. My Lord, the appellant herein was the plaintiff in the civil suit number WA12 BNCVC 21 238 2020 at the High Court, whereas the respondent named here was a defendant in the said civil suit. My Lord, to assist the court in clarifying the case, I shall now submit a summary of facts. My Lord, the appellant in this case is Razman bin Talib, was a member of the Royal Malaysian Police Force, holding the rank of Police Inspector since 2016. After graduating from Royal Malaysian Police College Kuala Lumpur, the appellant started to serve at the Royal Malaysian Police Headquarters Kuala Lumpur under the Crime Investigation Department, and the respondent is the Inspector General Police Malaysia in this case. My Lord, on the 1st of August 2020, the appellant received a show cause letter from the disciplinary committee which dated 31st of July 2020. And in the letter, the disciplinary committee required him to explain the 6 charges against him and to show cause why disciplinary committee, with a view to dismiss, ought not to be taken against him. And according to the show cause letter, there are 6 charges that put against him. And the first charges is a corruption. The second charge is dereliction of duties. The third charge is failure to report the gambling activities on the 17th of July 2020. And the fourth charges is failing to take necessary action against Mr. X. The fifth charge is the failing to take necessary action against Mr. Y. And finally is fail to take the necessary action against Mr. Z. So upon the receiving of show cause letter on the 7th August 2020, the appellant wrote an email to reply to the disciplinary authority. In the email, the appellant denied all the charges that made against him and plead that he will have sight of the evidence and be given an oral hearing to enable him to cross-examine the witness that had implicated him in the activities as alleged. But all his requests was being denied by the authority. My Lord. On the 14th of August 2020, the appellant received a letter from the disciplinary committee and saying that he was found guilty and dismissed him from the service. On the 21st of August 2020, the appellant commenced a legal proceeding at the High Court of Kuala Lumpur, and he sought for a declaration in the High Court that his dismissal from the police force at the 14th of August 2020 was unlawful, unconstitutional, void, and of no effect, and that of all intent and purpose he was still a police officer of the rank of police inspector. On the 20th of October 2020, the High Court ruled that there was no flaw in the disciplinary board decision-making process and dismissed the application. The appellant is not satisfied at the decision made by the High Court and thus appeal to this honourable court. My Lord, there is the main issue that we present before this court is that whether the learned High Court judge is correct in fact and in law on his finding that there was no flaw in the disciplinary board decision-making process. And to determine this issue, we would like to direct this honourable court to look into another 2 related issues. First, whether the appellant gives the right to be heard during the dismissal, and second, whether the appellant given the right to accept information during the dismissal. My Lord, if there is no further request, I shall now pass the floor to my co-counsel, Alisa, to continue with the submission of the first issue. My Much obliged.
My Lord, I appear before you on behalf of the appellant. I'll be presenting on the first issue. For the first issue, my Lord, whether the appellant given the right to be heard during the dismissal. My Lord, for the first issue, it is our submission that the appellant was not given the right to be heard during the dismissal pursuant under Article 1352 of Federal Constitution. We submit that the public servant's right to be heard in Malaysia is mandatory as expressly guaranteed by Article 1352 of Federal Constitution, where it provides that no member of such a service as aforesaid shall be dismissed or reduced in rank without being given a reasonable opportunity of being heard. Provide under Article 1352 of Federal Constitution, it adopts the common law concept of natural justice where a right to be heard to any public servant in case of dismissal or reduction in rank by adopting the term reasonable opportunity to be heard. Because of that provision, public servants have to be accorded with such an opportunity before an action of dismissal or reduction in rank can be made out against them to avoid the bias and prejudice. Other than that, in accordance with the principle which provided by the Article 135 of Federal Constitution, this right is further emphasized by Regulation 34 subsection 1 of the Public Officers Conduct and Discipline Amendment Regulation 2002 and procedurally regulated by Regulation 37 of the same regulation. My Lord, in Raja Abdul Muzaffar Shah 1995, the disciplinary board has failed to exercise procedural fairness in making the judgment for dismissal for the dismissal. According to the Gopal Sri Ram, I do prefer the term procedural fairness instead of the rule of natural justice. Procedural fairness connotes that administrative body must adopt a fair procedure based on the fact of a particular case before them. In the above case, the Court of Appeal held, inter alia, although the settled principle is that the right to be heard does not in all cases include a duty to afford an oral hearing, in some instances, the failure or refusal to provide such hearing could render a decision to be null and void. In introducing the new concept of procedural fairness, Gopal Sriram did not forget to mention that in some instances, the failure or refusal to provide a hearing could render a decision null and void. We also like to cite the case of Yusof Sudin against Ruhanjaya Perkhidmatan Polis and another 2012, where the fact of this case is very similar to our current case. The appellant in this case wrote a letter to disciplinary authority. In the letter, appellant specifically stated if his explanation is insufficient to exculpate him from those charges, he prayed that an oral hearing by way of inquiry under Order 26 of the General Order 1980 to be given to him. However, the appellant was dismissed by disciplinary authority without given an oral hearing. The court held that there had been a clear breach of Article 1352 of the Federal Constitution and Order 26 of the General Orders 1980 in the disciplinary proceeding taken against the appellant, which renders the disciplinary proceeding to be null and void. Zulkifli Makinuddin, Federal Court Judge, in this case, allowed the appeal raise the view that there is a request by the public officer for an oral hearing after he had denied all the charge and exculpate himself by furnishing credible evidence in the representation letter. By virtue of the Order 26, Subsection 5 of the General Order 1980, the officer should be accorded an oral hearing to satisfy the requirement of the Article 1352 of the Federal Constitution. Back to our current case, the appellant on the 1st August 2020 received a show cause from the disciplinary committee which dated 31st July 2020. When upon receiving the show cause letter on 7 August 2020, the appellant wrote an email to reply to the disciplinary authority. In the email, the appellant denied all the charges made against him and plead that he will have sight of the evidence and be given an oral hearing to enable him to cross-examine the witnesses that had implicated him in the activities as alleged. But his request was denied by the authority. If court has no further requests, I shall pass the floor now to my co-counsel Muhammad Akmal Safwan. Thank you.
My Lord, I'm Muhammad Akmal Safwan, the co-counsel of the appellant, and I will be further for this submission. The appellant in our case was not given the right to be heard. Before he was being dismissed, the disciplinary authority only given Razman chance in writing to defend himself. Based on the case of Yusuf bin Sudin against Suruhanjaya Perkhidmatan Polis and another, we humbly submit that the written submission made by the appellant is not sufficient in order to support his case. He must be given the right to defend himself by oral. In short, we submit that in our case, the disciplinary authority has denied his basic right to be heard during the dismissal. By referring to the Article 135, subsection 2 of the Federal Constitution, and also the mentioned case, we urge this Honorable Court to consider the issue of right to be heard is fatal in this case. We pray that this court will make an upright decision to ensure the right of Malaysian citizens to be protected. At this point, we would like to rebut the case which put forward by our opponent. The case which is most unfavorable to us, which put forward by our learned friends in the case of Lembaga Tata Tertib Perkhidmatan Awam Hospital Besar Pulau Pinang and another versus Atrabadi Perumal. In this case, the court stated affirmatively that there should not be any more lingering doubt as to what the phrase right to be heard or ability of being heard mean at common law, or in the statute. It must be accepted that the issue has been settled, as well as can be on the authority cited above. He ruled that the right to be heard given by Article 135 subsection 2 of the Federal Court doesn't not require that the member of the service facing the disciplinary charge be given an oral hearing. However, we should lead this Honorable Court to the case of Yusuf bin Sudin against Suruhanjaya Perkhidmatan Polis and another, where in this case, the Court of Appeal stated that if the principle laid down in Atrabadi case is to apply to all cases without exception, it will appear no oral hearing may be claimed in disciplinary proceeding. Thus, this will be the significant purpose and implication of Article 135 subsection 2 as constitutional right. The liberal interpretation may also be contributed by the attitude of the court incorporating the right to be heard in Article 135 subsection 2 with Article 8 that all persons are equal before the law and have equal protection of it. And Article 5, there are no person shall be deprived of life or personal liberty save in accordance with law. In addition to that, we would like to refer this Honorable Court to the case of Abdul Cik Mat against Pengurusi Suruhanjaya Pasukan Polis. The Court of Appeal held that Aldi Atrampatam rules stated that a decision cannot stand unless the person directly affected by it is given a fair opportunity whether he has right to state his case as well as to know the answer of the other side case. It was held inter alia that the right of hearing is his right to the minimum standard of fairness and must not be confused with the question of whether the officer was guilty of the disciplinary offense. In carrying out the disciplinary procedure, natural justice required that the disciplinary authority must employ a means that justifies an end rather than the end of justifying the means. Most importantly, we would like to highlight this court the case of Vijaya Rao anak lelaki Supermaniam against Suruhanjaya Perkhidmatan Awam Malaysia, where this honorable held inter alia where there is request by public officer for an oral hearing after he had denied all the charges and appeared to have exculpated himself by furnishing credible evidence. The officer shall be afforded an oral hearing. An oral hearing should be granted when there is an request, and when the disciplinary authority is faced with two sets of facts, document and also evidence, the court must fully consider the circumstances of each case before the court could be conclude whether or not the right to an hearing has been rightly observed by the disciplinary authority. By referring to all the authority and facts stated above, it is sufficiently established that the disciplinary board has failed to maintain the minimum standard procedure fairness, and the action is contradicting with Article 135 Subsection 2 of the Federal Constitution of Malaysia, expressly provide the right to reasonably opportunity of being heard. This right is specifically bestowed to the public servant facing disciplinary proceeding. In fact, this right is specifically bestowed to the public servant facing disciplinary proceeding. In fact, this right is derived from the common law principle of natural justice. My lord, if the court has no further requests, I shall pass the floor to my co-counsel Zaiful to continue with the submission of the second issue. Thank you.
My lord, I, as the co-counsel, shall now explain on the second issue whether the appellant given the right to accept information during the dismissal. On the second issue, we would like to direct this honourable court pertaining the issue whether the appellant given the right to accept information during the dismissal. In Samsiah binti Ahmad Syam versus Public Service Commission 1990, 3 MLJ 364 stated that fair procedure include the duty of an arbiter not to be take account matters that have not been first put to the accused, and he given an opportunity to rebut or to comment upon the same. It is a clear-cut right that in the dismissal of the public service of a party concerned to know the case which is made against him. Also, in the case of Surinder Singh Kanda versus Government of Federation of Malaya, the private counsel defined the basic component of a right as it was stated that before the service of an employee can be terminated on the ground that he has committed some misconduct which deserve the punishment of dismissal, he should be adequately informed of the accusation made against him, and he should be given a fair opportunity to correct or contradict them. One of the principles of natural justice is that no one shall be condemned unheard. Also stated that if the right to be heard is to be real right, which is worth anything, it must be carried with a right in the accused man to know the case which is made against him. He must also what evidence has been given and what statement has been made affecting him, and then he must be given a fair opportunity to correct or contradict them. Also mentioned, it stated that it follows, of course, that the judge or whoever has to adjudicate must not hear evidence or receive representation from one side behind the back of others. According to the case of Via Jaro anak lelaki Subramaniam against Suruhanjaya Perkhidmatan Awam Malaysia, the learned judge stated that the general principle on this issue may be summarized as follows. Concomitant with the right to be heard is the right of a person to know the case made against him. Second, he must know what evidence has been given and what statement has been made affecting him. And the third one is he must be given a fair opportunity to correct or contradict them. The Court of Appeal also made a reference to the case of Muhammad Zulhazi Muhammad Zulkafli against Suruhanjaya Pasukan Polis Diraja Malaysia and others. In this case, the Court of Appeal held that in order for an appellant to prepare an effective defense against his charge, he needed to have a sight of the allegations made against him and to have the opportunity to rebut each and every statement that might be implicate him in the offence. Therefore, the court ruled that there was a breach of natural justice in the non-supply of a material document to the appellant in this case. My lord, we submit that the heart of the unfair dismissal jurisdiction has two halves. One is the need of a valid reason for the dismissal. The other need for a level of procedural fairness. The valid reason must be related to the employee capacity or conduct or be a genuine redundancy. Absent a valid reason, the dismissal is necessarily unfair. Even with such a reason, procedural fairness may be so breached that dismissal is unfair. Therefore, we contended that the fair procedure for employee facing dismissal are First, there must be a notification of the reason. Second, an opportunity to respond to reason relating to the employee capacity or conduct. The third one, an entertainment where reasonable to have a support persons present at any formal discussion. And finally, the need for a warning where unsatisfactory performance is alleged. A person is entitled to know the case against him and have a chance to rebut it. Same goes to this appellant. By referring to all the authorities and facts stated above, it is sufficiently established that there is no procedural fairness and appellant right to not access the document information used to support his allegation for dismissal has been denied and disregarded. My lord, lastly, we would like to submit to the court should find the infringement of right to be heard will render the decision made by the authority to be null and void. Firstly, on the case of Raja Abdul Muzaffar Shah, Gopal Sriram, the learned judge, stated that in some instance, the failure or refusal to provide such hearing could render a small decision null and void. Secondly, in the case of Yusuf Sudin versus Suruhanjaya Perkhidmatan Polis and others, the court held that if the dismissal being done without proper oral hearing being given, the decision shall be null and void. Therefore, my lord, we humbly submit that as the right to be heard of our appellant has been infringed, the decision made by the disciplinary department should be rendered a null and void. Thank you, my lord.
My lord, to wrap up our case, we submit that based on all the authorities and evidence from the appellants and as highlighted above, and in light of the finding made by the learned High Court judge, we humbly submit as follows. First, the learned High Court judge is err in fact and in law on his finding that there was no flaw in the disciplinary board decision-making process. Secondly, we submit that the appellant was not given the right to accept information and right to be heard during the dismissal. Thirdly, the appellant had been deprived of his constitutional right under Article 135(2) of the Federal Constitution. Therefore, the appellant humbly prays the appellant's appeal to be allowed by this honorable court. My lord, if there is no further inquiries, I shall now rest my case. Much obliged.